You're learning about legal options today because you've been injured and feel that the injury was not your fault, but was caused by the actions of others. To put it in legal terms, you have a personal injury case. For the next few minutes, we'll discuss some of the key elements of a personal injury case and try to answer some of the most frequently asked questions. Only your attorney can advise you regarding the circumstances of your particular case, but we can provide background information that will help you prepare for the process. The law says you are entitled to be restored to the condition you were in before your injury, and that you must be compensated for that injury, any disability you have suffered, any loss in earning capacity that results from your injury, and any lost property. The fact that you have been injured, however, is no guarantee that you will receive compensation. To settle your case, your attorney must persuade the party responsible for your injury that the incident occurred as you say it did, that you have been harmed, and that you deserve compensation. Usually, if the other party is persuaded, your case can be settled without going to court. If the other party refuses to accept responsibility for the injury or disagrees regarding the amount of compensation, your case may have to be resolved or settled in a trial. Or you may be able to take advantage of a process called Alternative Dispute Resolution, or ADR. In either case, you and your attorney will be working together as partners. To demonstrate how this partnership works, we'll follow a typical personal injury case. This is Rebecca. She was injured in an automobile accident in which the other driver ran a stop sign and hit her car as she was driving through the intersection.
Why don't you begin by telling me how you were injured?
Well, I was driving home from work. At the corner of 3rd and Oak, the other car ran the stop sign and plowed right into the side of my car. I had my seatbelt on, and that's probably why I wasn't more badly injured.
Is there a police report on the accident?
Yes, I have a copy right here.
Rebecca thought about meeting with her attorney today and came prepared. This is a good idea. One of your responsibilities to your attorney is to provide complete information. Your attorney must know all the facts of your case in order to achieve the most favorable settlement possible. There may be facts that weaken your case or are embarrassing to you, but you must share these with your attorney, as well as those facts that support your case.
I got out of the hospital the day after the accident, but I haven't been back to work yet. I just don't feel up to putting in a full day at work.
If your doctor has told you not to work, then you should follow your doctor's orders. But if the doctor says it's okay to work, you should. We don't want to be accused of using your injuries as an excuse for not working. I'll need to get copies of your medical records, including your past records and your employment records, as part of our investigation.
Your attorney will use the information you provide to begin a formal investigation of your case. As the injured party seeking compensation, you are known as the plaintiff. The other party in the case is called the defendant. Your attorney's investigation will seek to identify all the defendants who may be legally responsible in your case. For example, in Rebecca's case, the other driver is a defendant, and the other driver's insurance company is also a defendant. If the other driver failed to stop at the intersection because the car's brakes failed, a car maker or a mechanic may also be defendants. Another part of the investigation is to determine the extent of your injuries or disability. To do this, you will have to provide access to your medical records both to your attorney and to the attorneys representing the defendant or defendants. Other information, such as your employment records, income records, and estimates of your future earnings, will also be required.
What sort of continuing medical treatment are you receiving?
Well, I see a physical therapist twice a week, and I take medication for the pain on a daily basis.
So this accident has really changed your life?
Yes, it has. How long do you think it will take to get a settlement?
It's hard to say, but we want to be sure we understand the long-term effects of the injury. We don't want to rush into a quick settlement and then find out later that you need continuing medical treatment.
The information gathered during the investigation will be used by your attorney to determine if your claim has a chance for success, to determine what laws apply, and to determine the appropriate amount of compensation for your losses. Making these determinations will require time, research, and possibly the services of experts.
I know you want to settle this case right now, but before we settle, lots of things need to happen. First, we need to wait until your medical treatment has ended. That way, we'll have a better understanding of the long-term effects of the injury. When your treatment is complete, I'll contact your doctor for a permanency report or a final report. This document will explain your physical condition, what your disabilities are, whether your injuries are permanent, what long-term medical treatment you may need, and whether the injury will affect your future ability to work.
I see. How much do you think this will all be worth?
It's much too early to tell. The amount will be based on the information we gathered during our investigation. The law provides that you should be compensated to return you to the state you were in before the injury. Obviously, this includes paying your medical bills, repairing or replacing your car, and compensating you for any work missed as a result of the injury. It can also include compensation for past and future pain, suffering, disability, disfigurement, or discomfort. We can also seek compensation for the loss of social or educational experiences and losses to your family that have resulted from your injury. For example, if you are now unable to enjoy the family activities that you enjoyed in the past, that can be considered part of your claim. So determining the amount is a complex matter that will require me to do additional research. But I can tell you that we are not looking at millions of dollars. We need to have realistic expectations for the amount of the settlement.
The amount of your settlement will depend on a number of factors, in addition to the extent of your injuries. For example, the funds available to the defendant will have a significant bearing on the amount of the settlement, and even on whether you proceed with a claim. If the other driver in Rebecca's case has no insurance and has no financial assets, there is little likelihood of receiving any money at all. If the other driver has an insurance policy, then the amount of that policy will affect the settlement as well. Other factors that affect the settlement include the location of your case, that is, the jurisdiction in which a trial would take place. If juries in your jurisdiction have a history of making large awards to accident victims, an insurance company may be more likely to avoid a trial by offering a larger settlement. If your particular situation involves an injury that occurred in the course of your work, your case may fall under laws pertaining to workers' compensation. Your attorney can explain how the amounts for workers' comp cases are determined. If you do decide to proceed with a lawsuit, you and your attorney have a limited time to file that suit. Some states have a statute of limitations that limits the time you have to file a suit. For this reason, it's important that the investigation get underway.
What if I'm not finished with my medical treatment before the statute of limitations runs out?
If that happens, we'll ask your doctor to address that in the permanency report. That way we can make a decision on going forward with a lawsuit.
Even though it is likely that your case will be settled without filing a lawsuit, it is beneficial to select your attorney early in the process. Your lawyer can shield you from the phone calls of the defendant's attorney or insurance adjuster. He or she can gather the information necessary to support your case while memories are still fresh. Your attorney may also be able to preserve evidence that would otherwise be lost. And your attorney can identify and work with experts such as accident reconstruction specialists, physicians, and accountants early in the investigation process. When you begin working with your attorney, be sure you understand the fee arrangement for your case. There are two common ways to approach your legal expenses. With a fee-for-service arrangement, you pay your attorney fees based on the amount of work done on your behalf. That is, you pay for the hours your attorney spends on your case at an agreed-upon hourly rate. And you pay this rate whether you collect from the defendant or not. In addition to the hourly rate, you pay for expenses such as travel, expert witnesses, accident reconstruction, and so on. The other common arrangement is to pay your attorney a contingency fee. This means that your attorney will receive a percentage of the settlement, if any. With a contingency fee arrangement, the expenses for the case are deducted from the settlement. The attorney's percentage is deducted, and you receive the amount that remains. Whichever fee arrangement you agree to, be sure you understand what expenses and costs you must pay if you win your case, and what your costs will be if you do not win.
If we are unable to reach an acceptable settlement with the other side, and we do proceed with a lawsuit, there are some issues you must understand. The first is discovery. Discovery is a process through which each side will try to find out as much as possible about the other side's case. The defendant's attorney will want to look at your medical reports. They'll want your income and work history statements, and you may have to be examined by a doctor selected by the defendant's attorney. This is called a compulsory medical exam. The defendant's attorney will also want your medical records from the past to see if there are previous injuries that could explain your current condition. During discovery, you may have to give a deposition. This is a meeting where you'll be asked questions under oath by the defendant's attorney, and we may take depositions from witnesses who will appear for the defense. If we do have to provide a deposition, I'll be with you every step of the way. Discovery can also include interrogatories, which are written questions that you must answer in writing. If you have to answer interrogatories, I'll be working with you through the entire process.
What happens after that?
After discovery, we'll have several options. One option is to settle the case. The other side will see our evidence and we'll see their evidence, so we'll both be in a position to evaluate the chances of winning the case in court. With this in mind, we may be able to negotiate an agreeable settlement. Another option can be to utilize some sort of alternative dispute resolution, or ADR. ADR is gaining popularity because it can be faster and less costly for both parties than going to trial.
One method of alternative dispute resolution would allow each side to select one lawyer on a three-lawyer panel. The third panel member would be an attorney selected by the other two. The panel makes its decision based on the facts of the case and the law that applies, and both the defendant and the plaintiff must agree to abide by the panel's decision. This is called binding arbitration. Will your personal injury case be settled out of court? The course that a particular case will take is not easily predicted at its beginning. For this reason, you should follow some simple guidelines to protect your case. First, don't talk to or write to anyone about your case, including insurance companies, friends, and coworkers. Second, follow your doctor's instructions. You should talk openly with your doctor about your health problems and treatment. But don't discuss other aspects of the case, such as who was at fault or how your case is progressing, with your doctor. Your doctor should only have information regarding your health situation, not your legal situation. Save these conversations for your attorney. Also, remember, the other party's insurance company may conduct surveillance to try to catch you doing something that would prove your injuries are less severe than you are claiming. So you must follow your doctor's instructions at all times. Third, stay in touch with your lawyer. This is especially necessary if something changes in your medical treatment or your work or living situation. Fourth, you may want to inform your friends and coworkers that the defendant's attorneys, investigators, or insurance company may be contacting them. They are under no obligation to talk about the case, but they may do so if they wish. If they choose to talk to representatives of the defendant, you should encourage them to always tell the truth about the case.
After we complete the investigation phase, we'll discuss the value of the case. This will be the amount that you and I submit to the defendants as part of our settlement offer. This offer will present what we have learned during our investigation, will describe how your life has changed as a result of your injuries, and will make a demand for a specific amount. Then, we'll wait to see how the defendant responds to our demand.
How will I know whether to settle, go to trial, or use ADR?
Those are decisions that only you can make. I can give you advice based on the law and on my experience with similar cases, but I can't settle the case or go to trial or use ADR without your consent.
Your attorney brings experience, knowledge of the law, and the resources of his or her office to your case. You bring your knowledge of the facts, and your willingness to make some hard decisions to the partnership. You and your attorney will work together to achieve the best outcome possible in your personal injury case.